Good morning, everyone. I am sorry that I cannot be with you in person today, but I did want to take some time just to talk to you a little bit about Title 4E adoption subsidy benefits. As many of you know, I have been working in this area about 20 years, and it unfortunately does not lend itself to quick coverage. So I hope that you will take some time to look at the materials and absolutely to reach out if you have any questions. Back in November of 2017, we thought we had good news at the end to having two separate eligibility determination processes for the adoption subsidy, but in early 2018, the feds decided to delay final implementation until 2024. So here we are still talking about this process. I've talked a lot over past years about the background of the subsidy, and I know that many of you are already familiar with this, so I'll just remind you that this benefit came out of the Adoption Assistance and Child Welfare Act of 1980, which is codified at 42 U.S.C. Section 673. It provides federal matching funds, about 60% in Georgia, for the adoption subsidy benefit, similar to how the feds provide funding for foster care per diems. And it helps remove a financial disincentive for children to be adopted and remain in care. Initially, before this law was enacted, a lot of families, when they adopted children, would lose the foster care per diem that they used to provide for the needs of the child and not get anything else to help provide for those needs that remained post-adoption. There's also a financial impact for the states, as states are expected to receive a cost savings from moving children out of the system and into permanent family homes. And there are incentive dollars available for the states if they place a number of children over a baseline into adopted placements. Really, the impact for you is avoiding malpractice, as there is a fiduciary duty to make sure that the clients know about these benefits. And hopefully this presentation will just help you do some issue spotting and know when you have a subsidy benefit that needs to be addressed. I don't want to get in the weeds about the sources of law for this, but as I mentioned, it does come out of a federal statute. The law has changed twice. Back in 2005, there were some revisions that limited eligibility to children who had been in foster care at some point or were SSI eligible. Prior to that, there were more ways for children to qualify for the benefit. But that law tightened up some of the eligibility requirements. And then in 2008, Congress created a phase-out period for the old AFDC eligibility requirements, which is where we had hoped to be at the end of right now and being done with that phase-out period, but that's what's been extended into 2024. So right now we're still really dealing with revisions of the law from 2008. So you do need to know too that there are a few other places that you can find applicable sources of law for adoption subsidy. There are some federal regulations. There is a policy guidance document from the Children's Bureau, the Child Welfare Policy Manual, but I would be very careful with that. It can be out of date. It may refer to 2005 provisions or to not applicable provisions only, to things that don't really matter at this point. And as I was updating the materials for this seminar, I actually even had trouble accessing the site. So I do still cite it in my papers, but just be aware that it's really more informational, persuasive than mandatory. There are also state statutes, state regulations, state policy guidance, especially for procedure. Georgia has a policy manual. And if you're going to handle these cases on appeal, you would need to be up to date on administrative law procedure because the appeals are handled in the administrative setting here in Georgia through the Office of State Administrative Hearings. So what exactly are the Title 4E adoption subsidy benefits? There are 4 aspects to it. I'll touch on each of them at least briefly. There is a non-recurring benefit that I'll talk about, a one-time benefit. There is monthly maintenance assistance and Medicaid, which go together and are what we typically think of as the subsidy when we're talking about the adoption subsidy. That's usually what people are talking about, is the monthly benefit plus Medicaid. And then there are some special services benefits that are post-adoption. So I'll look at each of these in turn. For the non-recurring benefits, all that has to be in place for a child to be eligible for non-recurring benefits is that the child needs to be special needs. This is based on a state-specific definition that's usually tied to minority status and age and disability and sibling groups, to those groups of children who tend to linger in care and may be seen as more challenging to place in permanent adoptive placements. There are a range of benefits depending on the state. I have seen reimbursement rates for the non-recurring benefit as low as $500, and the max under the federal statute is $2,000. Georgia's currently at $1,500 for what it reimburses, and these are to cover legal costs related to the adoption, but they can also be used to cover like travel expenses that are incurred during the placement process. So it is possible that an adoptive parent could come to the point of needing to do the legal proceedings for the adoption and have already used some or all of the non-recurring benefit that's available. So while this benefit can help defray the cost of adoption, it does not always bring the total cost down to zero. Actually, I will say one more thing too about the non-recurring is that attorneys need to know that you could ask your clients to pay you and get reimbursed after, but what's more common is for attorneys to accept direct payment of the benefit once the adoption is final. So let's look at the subsidy. Monthly maintenance and Medicaid. Again, this is sort of a complicated area, but I do want to touch on what these benefits mean to children and families. The total amount over time can be quite substantial and helpful to a family. The minimum benefit is a little under $400 a month. Most of the subsidy benefits, just for a child who's just coming out of foster care and doesn't have any special needs, is in the range of $400, $425, $450. And the Medicaid benefit is a huge benefit. So over time, since these can extend up to age 18 or 21, this can be a substantial help to the family. It is intended to cover expenses such as clothing, special dietary needs, ordinary medical and dental care, special education needs, preschool, daycare. But if those expenses are not incurred, that base subsidy rate could be something that the parents save towards the child's college education, for example. So it is based on the child's eligibility, not the adoptive parents. The base rate is, and that rate can be up to 100% of the foster care board rate, not equal to, up to. The rates are a little bit lower for the adoption subsidy, but that benefit is for the child. And there can be specialized rates, sometimes called, they were previously, once upon a time, called level of care, now specialized rates, which are for children who have more extreme needs. Maybe they have a really challenging medical condition that requires a lot of care, and those rates can be higher than the base rate. They're negotiated with the parents. They will look at the adoptive parents' income. In the case of a specialized rate, they will look at community resources that are available to provide for the child's needs. And that rate is heavily negotiated. The base rate does not take into account the adoptive parent's financial status. There are some fully state-funded benefits. Again, the subsidy is designed to be something that's co-funded by the feds and the state, and Georgia gets about 60% of its funds from the federal government. But there are some solely state-funded benefits. You will often see these referred to as 4B. If you see that, that means that child subsidy benefits are coming out of the state-funded pot. And this is for children who are in the permanent custody defects of DHS when they're placed on adoptive status. And that's the point at which the child's legally free and the forms, the intent to adopt forms are signed. And the child has to have been deemed not eligible for the federal adoption subsidy for some reason. Although the child still has to be special needs to qualify for this state-funded benefit, and the adopted placement has to be improved in accordance with state and policy guidelines. For the families, really, there's not a lot of distinction for them. They get their check for their subsidy benefit, and they don't really need to know whether they're federal 4E or state 4B. But where it does come into play is occasionally if a child has a disrupted adoption and goes into a second adoptive home, these state-funded benefits do not carry over to subsequent adoptions unless that adoption also meets their criteria. The child's permanently in the custody of defects, which is very uncommon. So that's where I do see a difference. I have seen some families who were adopting a child whose original adoption had disrupted and got denied for the subsidy benefits, which we thought would carry over from the previous adoption, and it turned out that those subsidy benefits were fully state funded, and that's why they were not carrying over. I also wanted to mention deferred applications, which are for children who are in state custody but don't have needs that rise to the level of special needs. They don't meet the special needs criteria, but maybe they have some background factor that indicates they could be special needs. So let's say that a child who was heavily drug exposed but isn't showing any effects from that right now. Maybe they're a 1-year-old. Maybe they have a strong family history. Birth mom had lupus, and there's some indication that maybe the child has that now. But that cannot be definitively diagnosed until around age 5. So in those cases where there are these background indications that the child might develop a special need down the road, if that child is in state custody, the state can enter an agreement with the adopted parents that say, we're deferring this application. So if it does happen that the child becomes special needs down the road, then we will activate the application at that time. So it's important to be asking about that. If you have a child who doesn't seem to qualify, typically because they're too young, they're under 2, then you want to make sure that this deferred application is in place. So the big takeaway with the adoption subsidy right now is that we thought we were going to have an easier process with determining eligibility for the monthly subsidy and Medicaid, but this whole not applicable thing is still around. We've extended the phase-out period to 2024, and so children under 2 still have to meet the old AFDC criterion that we were trying to get rid of, or be SSI eligible or in a sibling group. So I'll review really quickly. I encourage you again to take a look at the written materials on this because it's more understandable, I think, if you can kind of sit down and go through it. But I will tell you, I'll kind of go through the two paths to eligibility for children right now. The first is for applicable children, and once the phase out occurs, this is where we will be. These will be the requirements. So come 2024, this is what all children will have to meet. But for now, the applicable criterion that applies for children who are 2 or older are part of a sibling group. So this is where we froze. We were, with the phase out, this applicable criterion got 2 years younger every year. But when we paused in the phase out, where we were was at children who were 2 or older. So children have to meet that applicable criterion. And then they also have to meet what I call the status criterion, and that means that the child has to be in foster care at the time the adoption proceedings are initiated, or they have to be SSI eligible, or they have to be in a foster home with a minor parent in foster care, or they have to be being adopted into a new home and they qualified for that 4E subsidy in their prior adoption. And in some cases, they can be in a federally approved relative guardianship. This would be with other states because Georgia does not have this federally approved relative guardianship status. So first, the child has to be under 2, and the child has to be or part of a sibling group, and then the child has to meet one of these status, what I call the status criterion. Foster care, I will note, does include tribal foster care. And I also note that this is where some of the language in the statute itself becomes irrelevant. So, for example, one of the things that used to be under the status criterion was a child in foster care for 60 consecutive months. I'm sorry, under the applicable criterion was a child in foster care for 60 consecutive months could be applicable. Well, that's now meaningless because the applicable age is dropped to 2. So, you know, there's no way that a child who's 2 could become applicable by being in foster care for 5 years. So, the child will reach 2 before they've hit being in foster care for 5 years. So, as we go through this phase out, some of the language in the statute becomes irrelevant. Just want you to know. So, with these applicable kids, they've got to meet that applicable criterion. They've got to meet the status criterion. And then, of course, they have to meet the special needs criterion. So this means that the state has determined that the child can't return to the home of the parents due to termination or surrender, and that the child meets that state definition of special needs, and that the state has made a reasonable but unsuccessful effort to place the child with appropriate adoptive parents without providing a subsidy. Now, there's a unless with that, and I'll talk about that in a minute. So that's applicable. The children have to be they have to meet that applicable criterion, be 2 or older. They have to meet the status criterion, and then they have to be special needs. So for not applicable children, this is for any kids who are under 2, and we go back to the old eligibility criteria that we were trying to get rid of, which is that the child has to have been in foster care at some point, and at the time they went in, they were removed from the home of their parent, they had to have been AFDC eligible, or they had to be SSI eligible, in a foster home with a minor care, being adopted into a new home, in a federally approved relative guardianship. So some of those things still apply, but the main thing is they're kids under 2, AFDC criterion that it's kind of hard to keep up with, and special needs. So it's just a little bit different for our not applicable kids. So I wanted to try to make it simplified. So this chart here just shows which children you can expect to qualify for a subsidy. If they're SSI eligible, they're going to qualify for the adoption subsidy. If they've been readopted and they were eligible in the first adoption for the federal subsidy and they're still special needs, they're going to qualify. If they're 2 or older and they're special needs and they're in foster care, they're going to qualify. If they're under 2 and they're the sibling of a child who meets that number 3, and they're being adopted at the same time and they're in foster care and special needs, they qualify. If they're under 2 and they meet the old AFDC eligibility criteria and they're in foster care at some point, any point, not right at the time of adoption, and they're special needs, then they qualify. So this is a little handy sort of cheat sheet chart that you could look at down the road. I do want to go back to that language where they talk about the reasonable but unsuccessful effort to place the child with appropriate adoptive parents without providing adoption assistance, because I said there's a but, and it is that except where it would be against the best interests of the child because of such factors as the existence of significant emotional ties with prospective adoptive parents while in the care of such parents as a foster child. I'm seeing less of this lately, but there was a time when we saw a whole lot of when foster parents would advocate for getting the adoption subsidy for their child, DFACS would just threaten, well, we'll just move the child to a home where these benefits are not needed. And that is completely unacceptable. It goes against the intent of the federal statute, and it absolutely goes against the best interests of the child. So know that that language is there, and you can point to it if DFACS is making rumblings along those lines. Just a brief note about special services adoption assistance, this final aspect of the subsidy. These are to cover things like braces and emergency medical care that's not covered by Medicaid. It's limited to children who were in DFACS permanent custody, and there's a limited number of funds. So if a client comes to me in December, I'm going to tell them to wait and apply in January. So finally, the main takeaway for you is to advise your clients to apply. I have a waiver form, a notification form that's in the materials. Be prepared to assist if they need some help with negotiations, which is mainly providing documentation of the child's needs. Understand the rate. Clients need to understand, particularly if they're working with some private agencies, that those agencies might be padding the subsidy rate with additional funds that they have available, and so the adoption subsidy rate is going to be lower. They need to understand that. They need to understand that if there are any changes, if they move, they have to notify the state. If the child goes to live with someone else, they have to notify the state. It also helps to make sure that clients know that the adoption subsidy, when it's going to terminate, it'll end when the child turns 18, or if the child has certain specialized care needs, it'll end when they turn 21. And it also helps for clients to know that they do have a right to appeal if they feel like they have been improperly denied the subsidy, or if it's been improperly terminated. If you have any questions, please don't hesitate to reach out to me and ask. I am happy to assist, to provide guidance, and to point you to the policy manual provisions that could maybe answer the questions you have.